Good evening. Welcome to the Veterans Voice. This is Amanda Manier, your host. I am a veteran advocate and the managing attorney at the Veterans Law Group, and we have been working to represent veterans before the VA, pursuing their VA disability benefits for over 25 years. One of the joys of my job is to host the show every Tuesday night from 7 to 8 o'clock, answering your questions and providing support and information and things that are in the news happening that are affecting VA disability benefits. We are live this evening. Would love to take your call if you have a question about your VA claim, or if you are a family member or a friend of a veteran who you have watched kind of stumble through the process or be hurt by the process of getting VA support. Feel free to give us a call, 800-222-5222. I'd be happy to answer your questions, point you in the right direction if that's something that I can help you with, but I can probably always kind of point you in a direction that could be helpful to you, regardless of what you're dealing with. So again, we've been working with veterans for over 25 years, helping them kind of navigate the process at the VA. It is supposed to be a non-adversarial process, which that means that it's not supposed to be you, the veteran, against the VA, and you need a representative to argue your spot. It's supposed to be the VA, your representative, and you as a veteran all coming together to try to make the best decision for the VA, to get for the VA veteran to get the benefits that they need and are entitled to under the law. So it's supposed to be all of us working together. I know it doesn't always feel that way, and sometimes it can get a little contentious, but that's what my job is, and our entire team here at Veterans Law Group. Our job is to kind of be the go-between and between the VA and the veteran and their family, and ultimately, when your case gets heard, make sure all the ducks in a row for it to be easy for the VA to represent or to grant your case. I understand the frustration, all the paperwork and the bureaucracy and all of that kind of thing. We're going to talk about that a little bit tonight, some of those things that are coming out of the VA. Generally with these shows on Tuesday night, sometimes I have a guest, other times we're just live answering questions. And I typically will pick a couple of ideas of things that I want to talk about that are things that have come up over the last week, either in working directly with some of our clients, working with some potential clients, people who are seeking our representation, or sometimes just in our social media. So if you have a question, you again are more than welcome to contact us directly here at 800-222-5222, or you can always reach out to us via our social media. We have pages under Veterans Law Group. If you just search that on Facebook, Instagram, Twitter, YouTube, we are regularly posting these shows in YouTube so that you can go back and listen to some of them, as well as answering just some questions. I do have some short videos that answer, how do you get to a 70%? What are your PTSD? What do you need to prove? What to expect at an upcoming hearing if you've been scheduled for a hearing, things like that. So definitely check that out if you're not able to call us directly here this evening. There's been a few things that have come up, a lot of stuff in the news over the last week or so that I want to just kind of pick up here. If you've been listening to the show or really paying any attention to what's going on in the veteran community lately, you've probably heard about what is called the PACT Act, P-A-C-T Act. It is a recent legislation that is fully in effect, passed by both houses of Congress and signed by President Biden. And the biggest headline about it is generally about how it is helping those veterans who were exposed to burn pits while they were serving in the Gulf, going all the way back to 1991 with the Desert Shield, all the way up until the present. It certainly hasn't. There's no cutoff at this point. If you're familiar at all with how Agent Orange has been handled by the VA, it's basically, I've been saying this for years, it's going to be the next Agent Orange. So the idea is if you were in those particular regions during that time, and there's a list of countries, and you were ultimately later diagnosed with a certain number of conditions, most of which are respiratory as well as cancer related when it comes to burn pits. Agent Orange has a plethora of things. you don't have to show a direct connection between your current condition and your exposure in service. The VA will presume that your current diagnosis is related to that time in service, to what you were exposed to in service. So that's the big headline on this. There's also some other things that are huge with regards to a lot of our clients, that is expanding presumptives with regards to Agent Orange on a couple of new conditions, as well as instead of just always being about Vietnam, it expands exposure in Thailand, Guam, American Samoa, a lot of other countries. But I kind of run through that a little bit because we've talked a lot about that on the show. If it's something that you're interested in, you can go to our website at veteranslaw.com, click on podcasts, see some previous episodes. You can also go to the KABC website 790 and listen to previous episodes where we've gone into depth about what conditions are being covered, as well as what countries. But there's the one thing that has been brought up to me a few times. I've been asked some questions over the last couple of weeks as to why I haven't addressed the Camp LeJeune changes within the same legislation. So there's some things that have happened with those, some changes that have been made with regards to people who were exposed to toxic water while they were contaminated water while they served on the base in Camp LeJeune. So I just wanted to touch on that briefly, just so you are aware of it and make sure that if it's a condition or the situation in which affects you or your family, because this one in particular is supporting families in the way that they never have been, or civilians that served on the Camp LeJeune base, and how they can pursue justice for being exposed to this contaminated water. So buried within the PACT Act, and it's not entirely buried, but is what they are calling the Camp LeJeune Justice Act of 2022. And what it does is it allows veterans, their families, or other individuals who lived or worked with at least 30 days on the base between August 1st of 1953 and December 31st of 1987 to sue for harm exposure to contaminated water. So basically there were some contaminants in the water that people are exposed to during that period of time that resulted in a series of illnesses, including things like leukemia in children, other cancers. And up until now, there really hasn't been a provision for that Congress had said, okay, you have the power to actually sue somebody sue the government for this exposure because your child had ended up, because of this exposure, ended up with leukemia or that there's kind of things. And what's interesting about it is everything else through that particular legislation is about how you get benefits through the VA for conditions, illnesses or injuries while you were serving. This one is a little bit different. It applies to civilians, it applies to family members, and it's been a big deal. And if you've watched TV lately, you'll see a lot of attorneys that are promoting and advertising for it. It's not something that our office does. We work solely within the VA disability benefits. This is more of a lawsuit against the government. So there are a lot of law firms that are certainly handling those cases. It's basically kind of like the mesothelioma, where they have set aside a fund to provide compensation for people that fall within this. And how long and how big that fund or how long that fund is going to last is questionable. So if you fit within that, if your family lived within the Camp Lejeune area during those period of time, or if you were a civilian that was working on base during that period of time, definitely, do some due diligence. There's a lot of law firms out there that are pursuing it, but do some due diligence. I certainly do not have one that I'm specifically going to endorse. It's not, again, an area of expertise, but I wanted to touch base on that because I wanted to make sure that you all as listeners were aware that that was going on, both as civilians and veterans and their family, that was a huge part of the PACT Act that we haven't talked about so far, but definitely affects a lot of people out there. if you fit within that, again, just kind of do some due diligence and find some of the law firms that are pursuing those. I will tell you, just as a, I don't know, I guess touched my heart a little bit in reading some of the news stories, that the first applicant, or the first person who filed a claim, he was one of the first lawsuits for the water contamination. His name was, he's a Marine veteran, Jerry Ensminger. His daughter died of leukemia after he was serving for 24 years. He retired as a master sergeant. They had 4 children. His daughter, Janie, was conceived while he was at Camp LeJeune, and was diagnosed in 1976 with leukemia. She was only 6 years old, and she died of the disease 3 years later. So he was one of the first ones that filed this claim. Obviously, as he indicated, it's the worst thing you could ever happen to a parent, is to watch your child go through hell in dealing with this. So kudos to the Congress and Biden administration for finally getting this passed through and getting support for these families that have obviously long been dealing with this issue. And who knows how much is going to pass through generations. So I definitely wanted to touch on that before we go in. When we get back, there's a couple things I will say. First, before we go, if you do fit within the PACT Act, as we were talking early on, of being exposed to toxins as far as burn pits, in the past, the VA has said, oh, if you previously filed, we'll reach out to you. Now they're being pretty proactive about file your claim now and reach out now. So definitely get your file claim. Voice, we are discussing VA disability claims and things that are affecting veterans with their disability claims. We were recently just talking a little bit about the PACT Act and the new legislation and how it affects and opened up the Camp LeJeune benefits there. So if you have a question, we are live this evening. If you have a question, not just about that, but anything related to VA disability benefits, I'd love to take your call. Our number here is 800-222-5222. It's 800-222-5222. You can also submit questions via our social media. If you go to Facebook, YouTube, Twitter, Instagram, search Veterans Law Group, you can always submit questions there. Not only this evening while we're live, but you're welcome to submit questions throughout the week. I do often pick up questions from those postings to talk about on our live radio show if I feel that it would be something that would be helpful to our wider audience. So again, our number here is 800-222-5222. I just wanted to reiterate as we were going into the break, usually when the VA passes new legislation, or the Congress passes new legislation, or the VA issues new regulations, oftentimes the VA is kind of putting the brakes on. Okay, I think they're trying to avoid the big flood of claims they're going to get, as if they can avoid that. But so for some of these new conditions that are being granted for Agent Orange, or these new presumptive conditions related to burn pits, often veterans have filed those claims before and been denied. And so under certain legislation, if you've been denied those things in the past, the VA is supposed to then eventually grant those, assuming you meet all the criteria, back to the effective date in which you originally filed that claim. And so the VA has in the past often said, oh, you don't need to file these claims. Like, we'll get to you. Like, we're going to review all of your claims. And if you had one of those claims, we'll follow up. My representative, as a representative, my recommendation is always like, go ahead and file the claims. So I find it interesting that they are publicly putting out there, go ahead and file the claims. So if you have previously filed and been denied for any of those presumptive conditions with regards to the burn pits or Agent Orange, or you've never filed for them, but you have them, go ahead and file those and get those things moving. There's no reason to wait. It's all about effective date when it comes to your compensation. So let's take a caller. Let's take Jerry in Stanton. Jerry, welcome to the show.
Hello.
Hi, Jerry.
Yes. I'm a Thailand Vietnam vet, and I got that laryngeal cancer. From exposure.
Right.
And I was denied. I filed 18 years ago.
Okay.
But and there was another virus I obtained over there in Thailand, and I found that it causes the same type of laryngeal cancer,
Uh-huh.
and they gave me 80% compensation for that 10 years later after the Agent Orange claim.
Mm-hmm.
What do I do now?
So I would recommend, because you need to reopen your claim with the new legislation, I would recommend working with a veteran service officer in your area. My recommendation is generally in the Los Angeles County or in the counties around California is to go to the county veteran service officer that's near you.
I have a veteran service officer. I haven't contacted him yet.
Okay, so I would.
However, now that I have two claims against the same condition. What
Right.
takes precedent?
Well, it depends on the record. It's a little hard to tell because I don't know why they previously denied it versus why they later granted it.
They denied it because Agent Orange was not used in Thailand.
Okay.
And of course, they were lying. Now
Right,
they
of
admit
course.
it was used in Thailand.
Yes. So if you fit all the criteria with the law changing that says, yes, we used it in Thailand, and you don't have to prove that you were on the perimeter and all that kind of thing. If they previously denied you because of that, because that law has changed, it's likely that your case will end up being granted back to that original claim. So I would Go ahead.
Even though they granted me laryngeal cancer for a virus I obtained.
Yes.
So how can I have both claims? I don't.
Well, because it has
everything.
it has everything to do with the effective date. So if you were later able to get the claim granted based upon a different theory, based upon an exposure versus the Agent Orange exposure in the previous claim, then I still would argue that you should be granted an earlier effective date. So what you need to do is reopen your claim. So I would go to your veteran service officer, get it reopened. They may deny you because they don't understand what the theory is, and that's where a law office like ours would come in. But it's the idea also, if you say sleep apnea, they originally denied you direct connection for sleep apnea. You later refiled and argued it was secondary to PTSD, and they ended up granting that. And then in the future, the law changes and says, well, you should have been granted it to begin with. Then the argument is you should have an earlier effective date, which means you should have been paid for that 17 years versus maybe the 5 to 10 years. So the first step in the process is getting that claim reopened. And then there's the legal argument involved. So I would definitely go and get your claim reopened ASAP.
Well, thank you.
Sure. You're welcome. Thank you so much, Jerry, for calling in. And what Jerry's referring to in the Thailand changes is in previous to the PACT Act for Thailand and multiple other places, you had to show that you were on a certain Air Force base. There was a number of them that were identified during a certain period of time. And on top of that, you had to show that you worked the perimeter of the Air Force base. So effectively, the VA was arguing Agent Orange was used off of base, but not on base. So if you worked the perimeter, you might have been exposed to it. But if you were just, in the middle of the base, you weren't exposed to it, which, was laughable for lack of better word. You only ever lived in the middle of the base. You never touched anything else. So it's one of the greatest things that we have a number of cases that we've been fighting that, we would win a lot of those cases by giving testimony at the board before a judge, allowing the veteran to say, well, I was an airplane mechanic, and so by nature of my job, I had to go down to where we had the broken down airplanes that we pulled parts off of, and they were near the perimeter. And so you'd have to go through extra work to get it done. And now the VA is basically acknowledging that, if you were on that base during that time, you were probably exposed to Agent Orange. So it just makes it a lot more simple. But it really comes into key for a couple things to think about. There are a lot of conditions that are non-presumptive right now related to burn pits, or exposure a lot of digestive issues and things. So primarily it's cancer and respiratory issues. There are a lot of conditions that a lot of people believe are related to burn pits and exposure there. And if you think about it, if you go ahead and file those claims now, while even though they are not presumptives now, if they eventually become presumptives, you've basically kind of put a stake in the ground to show that if in the future those things get approved, your effective date should go back to that where you put that stake in the ground. So even if you have a condition that is non-presumptive for Agent Orange, for burn pit exposures, for asbestos, for any of those things, and you believe that it's related to service, it's worth the time to put in a claim, even if they just turn around and deny it, because again, you've kind of put that stake in the ground. So think about that when you are kind of looking at some of these issues that we're talking about this evening. Let's see, what else is going on in the VA world? Some interesting things, just to kind of throw out there. There's been some new legislation that has been proposed, and if you've heard this show before, I generally don't get hyped up about legislation. There is all kinds of legislation that gets proposed that maybe never passes. We get called a lot when something's in the news that's being hyped up about something that may change for veterans. In general, it's like, okay, let's see what kind of movement it has. Let's see what's expected to be passed, not passed. But we definitely pay attention to it and don't really get worked up about it unless things start to really move. This one is one that I find interesting. It's been in the news a lot over the last number of years. It's with regards to organizations, non-accredited organizations that are proposing to help veterans with their VA claims. So typically and there's, depending on who you hear, it's their sharks or they're predatory or they're, those kind of things. So let me just give you a really quick rundown. In order for anybody to represent a veteran before the VA, they must be an accredited representative. And that basically means that we are required to file a request to be accredited with the VA. We are under the watch of General Counsel, who has the ability to discipline and to revoke accreditation. So there's small organizations there's organizations like DAV, VFW, there's private attorneys like us, and there's a whole nother world of organizations that they are not purporting to be a representative of you, but they're charging a consulting fee to helping with the VA benefit. And I want to get into a little bit of some of the legislation that's being proposed. I won't go into it in a whole bunch of depth, but just to give you a little bit of awareness of what's going on in that. Good evening. Welcome back. This is Amanda Manier. You are listening to The Veteran's Voice here on 790 KABC. I am a veteran advocate and the managing attorney at Veterans Law Group, and I get the joy of spending every Tuesday evening with you all from 7 to 8 o'clock talking about what I love most, helping veterans and their families, specifically related to supporting them in navigating the VA process. An entity, as I try to remind them regularly, you're an entire entity set up to help veterans. Why do you make it so hard? It certainly should not be that hard. As I often say, that I shouldn't have this job because it should not be needed. You should not have to hire an attorney or need even to hire an attorney to get VA benefits. But our phones ring off the hook, and we are here to serve and support veterans and their families in getting what the benefits that they deserve. It's certainly one of those things. As before we went to the break, I was getting into a little bit about some of the new legislation that was being proposed for organizations that are proposing to help veterans with their VA disability benefits, but are non-accredited agencies. And I generally don't deal into legislation, but one of the things that I wanted to kind of point out here, and I would love if you're listening, we are live this evening. If you're listening, if you want to talk about this subject, or you've got a question about your VA disability claim, or how to have, I'll definitely table this topic to answer your questions. Our number here is 800-222-5222. That's 800-222-5222. Happy to take your call if you're a veteran, a family member of a veteran, or a friend wanting to know how to help a veteran in your life with regards to their benefits. The reason why I bring up this legislation is I want to make sure that everybody understands that in order to represent a veteran before the VA, you have to be accredited with the VA. And because of that accreditation, as attorneys, you have to file certain paperwork. As non-attorneys, you have to go through make sure you take an exam and make sure that you are qualified to properly represent a veteran before the VA. And one of the rules is that federal law and regulations prohibit anyone from assisting a veteran in preparation, presentation, or prosecution of a VA claim, or charging a fee for this assistance without being accredited. So a number of organizations out there all over the country, if you've had experience with one of these, I would love to hear. They're not always bad experiences. Many of them are good, but there's some frustration with it because there's no ability to regulate them. So those who are not doing good on behalf of the veterans or are being predatory, there's no, at this point, way to regulate them. So what's happening is that agencies out there or organizations are popping up out there where they will not take on power of attorney where they're officially representing the veteran, but they're charging basically like a consulting fee or a fee for medical examinations that's supposed to help your claim. And one of the things in working, the legislation out there is really focused on let's get rid of these for-profit companies that are benefiting off of veterans. And full disclosure, our organization is a for-profit law firm. We do represent veterans, but we do it solely on a contingency basis. And we cover all costs of any examinations, that kind of thing. So there is a risk involved when we take on a case that if we're not able to, and a benefit and a reward if we fight for your case and win your case. The organizations out there that I specifically maybe have some unsettlingness with myself about it is those who charge. I had a client the other day, he came to us and he had paid over $6,000 to one of these organizations who went and got him some medical opinions, but his case was still denied. And so he was out the $6,000 that he didn't really have and then came to us, to which we, of course, are never going to ask him for out-of-pocket money. We are going to pursue the claim, pay for those examinations, make arguments before the VA, make sure the paperwork is being properly filed. And we're always falling under requirements for continuing legal education. And if we misrepresent the veteran, we can risk our accreditation. So there's disciplinary actions that are involved with an accredited agency. That the problem the VA is having is some of these organizations that are not accredited and doing these consulting things. So there is new legislation that's being proposed to help regulate that. We'll see how far it gets. It is called the GUARD VA Benefits Act, governing unaccredited representatives defrauding VA benefits. It's amazing how the Congress comes up with these acronyms, but the GUARD VA Benefits Act, if you want to look it up. I will try not to get on my soapbox about that, but again, we are live this evening. If you have a question about your claim or how to help a family member, I've got a couple of questions that have come here through social media. You can always submit your questions through social media by searching Veterans Law Group, which is our organization, on any of the Facebook, Twitter, Instagram, YouTube. Happy to take your questions that way, although I love chatting with you directly because I can make sure your question is answered. Let's see. One of the questions that came up here is, how do I decide if or should I move my case to the new appeals process? So, great question. So there was, again, going back to legislation, there was new law that was passed that changed basically the process and procedures of an appeals. It didn't change a lot of substantive law, whether or not you were entitled to a benefit or not entitled to a benefit. It changed from what they call legacy appeals, which was prior to February of 2019 and post February 2019. So depending on when your decision came in, there's a little bit of fuzziness between that if you opted into new appeals early, which was called the RAMP program. But basically, the big picture is that you couldn't really be forced into the new appeals process. So if you've been working on your claim for a number of years, you were in the appeals process, and you were under legacy, you had to choose to opt into the new appeals process if you chose to, or stay in legacy. And I would tell you that early on, when they were offering people to opt into the RAMP program, which is in 2018, they were trying to get people to opt in. There was a lot of hesitancy among the veteran community I used to hear a lot, I don't want to be the guinea pig. I don't want to, like, this is a new process. I don't want to be the guinea pig getting into the new process. Now, years later, okay, we have a little bit more understanding of the new process, how the VA is handling that. And so those cases that are still in legacy, it's how do I know if it's a good decision for me to work to opt into the new appeals process? And I will say that my answer to this question has changed over time. Early on in the process, I was looking at a case purely from, would this case be affected by the few substantive law changes that existed in the new appeals process, or really is it just a procedural thing? So early on in 2019, 2020, partially into 2021, cases that were in the new appeals process were happening a lot faster than legacy. You would get a higher level review within sometimes a couple of weeks. You'd get a substantive claim processed within just a couple of months. Appeals to the board were handled within less than a year. As time has gone on, and obviously the backlog in the new appeals process has started catching up, we're seeing those time frames become more and more like what it used to be with the legacy appeals. So right now in the new appeals process, if you file an appeal at the board, it's likely taking 2+ years to see a hearing, which is what used to be in legacy. So the question is, do I stay in legacy or do I move to AMA? Here's the big picture. I mean, I'm not going to answer very specific without looking into it, but the big picture I will say is the VA is under a lot of pressure to close out those legacy appeals. And if you are in legacy appeals and you are under once you get a docket number at the BVA, you keep that docket number whether you go up or down the appeals process. So say your case was remanded by the board to go back to get a new exam, and then they issue a decision, they send it back up to the board. You still hold your same position when you go back up. If you get into and opt into the AMA, the new appeals process, you're going to get in line whenever you opt in. So if you've got a case that's been in legacy for a number of years, generally I would recommend you stay in the old appeals process, because you're especially at the board, you're likely going to be seen sooner because, one, you have an old docket date, which is, different than if you get in the back of the line if you opt into new appeals. And two, they are under a lot of pressure to close out those legacy decisions or close out those legacy cases. And so there are entire divisions within the VA that are focused solely on handling legacy appeals that are remanded from the board or legacy appeals at the board. So where early on in the switchover, I might have recommended, jump over because you'll be closer in line. Now it's definitely getting to the point as caseload shifts from the old legacy appeals to the new appeals. My recommendation generally is to stick where you're at, keep your place in line, don't move to a new process and get to the back end of the line. So I hope that that answers the question. It's a lot of strategy and legal, and I hope not too much legalese, but definitely I think if you're in legacy, stick with that for right now and don't necessarily get to the back of the line. Something that's interesting for any of you, like I kind of nerd out over this stuff, the Board of Veteran Appeals is required every year to submit a report to Congress. And within that report are statistics of how many cases are still in legacy, how quickly things are being decided, what the deposition is based upon your representation, all that kind of thing. You can certainly find that if you search for Board of Veteran Appeals, Report to Congress. This is Amanda Manier with the Veterans Voice here on 790 KABC. We are talking about VA disability benefits and veterans kind of navigating that process. A few things within the news that are affecting veterans and their families. We are live this evening. If you'd like to give us a call and talk about what's going on in your VA benefits case, get some advice or maybe point you in the right direction, our number here is 800-222-5222. You're also welcome, if you don't want to talk live on the air, to submit questions via our social media, Facebook, Twitter, Instagram, and YouTube. If you just search Veterans Law Group, you will find us there. I was just before we went into the break, talking a little bit about whether or not you should opt into the new appeals process, which seems, it's gone back to 2019 as being new, but there's still the old legacy appeals, and many people are still within that process. I would say a good probably 30-40% of the cases that we handle are still in the old appeals. We're keeping them there primarily because some are due to substantive law change. There's very little, but there was some that affect some of our cases, and others it's because we don't want to have our clients be put in the back of the line of the new appeals. We want to keep them where they're at in line for the legacy appeals, with the VA having as much pressure as they have on them right now to get through that backlog of the legacy appeals. Again, if you have a question you'd like to reach out to us tonight, 800-222-5222. I will also say that our office, Veterans Law Group, we do initial free consultations. You're always welcome to reach out to our office during the week. Our website is veteranslaw.com. That's veterans with an S. You'll see a little picture there that says see if we can help you, and fill out a form to request an initial consultation where we can review your case, see if it's something that we can help you with. You're more than welcome to reach out to us there as well. On YouTube, we're getting a number of questions, or I have gotten a number of questions along the same kind of subject line over the last week. And the biggest one, it's probably the most common question that I get when it comes to VA, is how long will it take? So if you file, and that changes over time. So while I answer this question now, it will go up on our podcast, and maybe somebody's listening to this years from now that I will say, or even months from now, I will say what I'm answering now as far as a timeline. It changes over time. The VA is notorious for shifting resources based upon what oftentimes the headlines are. Initially, when I got into this area of law, the headlines were all about it was taking a year to a year and a half for a veteran to get an initial decision on a claim. And so obviously, because of that, the VA shifted a bunch of resources meaning people and manpower, from the appeals department, and they were helping with initial claims to handle the hundreds of thousands of backlog that they had there. And then, as you can imagine, what would naturally happen with that is then the appeals becomes backlogged because those resources have been pulled away from that to do work in appeals. So that happens. It's just like the same thing with they shifted over to work with legacy, or because they wanted, they were initially working on the new appeals process because they wanted to make sure their statistics were really good there and it was showing that it's working really great. And then then they've got this backlog in legacy, and so they shift resources over there. So that's certainly a lot of what happens. But right now, I will tell you that our experience is an initial claim is taking 2 to 6 months, depending on the complexity of the claim, depending on whether or not you're willing to go to exams. They are still allowing not a waiver of exams, but a delay of exams based upon COVID and whether or not you're willing to go into a facility to get an examination. They will hold your case open until you are ready to do that. So that, of course, would delay your decision. But somebody who's just willing to go, and you're really seeing those decisions within, I would say, a 6-month period of time. And then what happens when you get that decision? Is it this decision you were looking for? Were you granted? Were you denied? Were you rated what you should have been rated? And there's an entire analysis that there's previous podcasts on, or I might maybe address in the future again as well, as to how do you really look at a decision and make a determination as to whether or not you should file an appeal or you should pursue it anymore, or whether you should just accept what the VA has given you. That's certainly a question and analysis that I go through a lot with our clients, a lot with initial potential clients. The decision itself, if you were granted service connection and you're given a percentage, the decision should indicate, say you were granted 10% for a condition. It should then tell you, in order to reach the next level, which may be 20 or it may be 30, depending on what the condition is, it should say in order to get granted 30%, you must show these symptoms or these conditions. So if you have those, and obviously it's something that you should appeal. It's definitely very statutory like that, in the sense that the law states these symptoms equal this higher percentage. It's not a matter of the VA just arbitrarily saying, we think that this condition that you have is affecting you 10% of the time or is causing a 10% disability. It's very much based on statute. So if you decide at that point you want to pursue service connection or pursue a higher percentage, then the next question is, what should you do with that? And I call generically across the board the next level, what you do with that if you decide to do anything, I call it an appeal. It could be a substantive claim, which basically means you've got new evidence. You have to show new evidence to show a substantive claim, a supplemental claim. And that's going to go back to just like this. It's the same level of employees that are working on the original claim. So they're just looking at new evidence, seeing if that new evidence is going to decide whether they should grant your case. Those supplemental, I'm having a hard time saying that today, supplemental claims, right now are generally taking 4 to 6 months, depending on whether or not they need to schedule you for an exams, all that kind of thing. So it's almost like going through the new claim process again. It's just that you already have maybe some foundation. Higher level reviews, that's the next level. And that is, you're not submitting any new evidence. You just want somebody with more experience at the VA to review the same evidence you submitted before and possibly come up with a new decision. Those are happening relatively quickly. I've got friends within NOVA, the National Organization of Veteran Advocates, which we're a member of. We all share information on forums. There's times in which we've experienced that as well. We file a higher level review, and within 2 weeks, we're getting a call from the VA to schedule an informal conference. So those are happening relatively quickly. But again, there's no new evidence. They're just looking at whatever was currently. So it's almost just like a double check by somebody with more experience. That's what they call that higher level review. And then if you're going to the board, if the next decision is you go to the board, right now we're seeing those, whether you are requesting direct, there's 3 different ways when you go to the board. You can say no new evidence. We just want a judge's opinion. Here's new evidence and please decide again. It's kind of like a supplemental, but you're going up to a higher level of review at the board, or you're requesting a hearing. All of those are taking a minimum of about 2 years right now. It's crazy. Their initial goal when they started the new appeals process was for them to issue a decision, even if you ask for a hearing within 365 days. And that's been blown out of the water. I think largely to do with the fact that they took away any sort of right to a hearing for a veteran to talk to the decision maker prior to the board. It used to be you could do that at the VA level. And now if you want to talk to the decision maker, you've pretty much got to go directly up to the board. And they saw a huge influx of requests for hearings that they say they weren't expecting, which I find interesting. Interesting they didn't anticipate that, but yeah, so appeals process does take a long time. And the question always is it worth it? Is it worth filing an appeal? Is it worth pursuing? And that's where my all-time advice always comes in when any veteran or a military member who's leaving the military, talking to me about my experience of 10 plus years, our experience as a firm of over 25 years. What's your biggest piece of advice? My biggest piece of advice, there's 2, but one is always the highest. Do not walk this journey alone. While it's supposed to be VA friendly or veteran friendly, it's supposed to be easy. Having a representative with if you're filing your initial claim with a veteran service officer, if you're filing an appeal working with an organization like ours, or DAV or VFW, if some of them are skilled in appeals, some are not, but it's been admitted to me by many times by people inside the VA that when a veteran has representation, the VA then has to kind of by default take an extra check because they know somebody else is going to be checking their work. And they know that if they don't get it right, the representative should raise a red flag and to file an appeal and all of that kind of thing. Where a veteran that's working maybe on their own, you may get a decision and just accept that that's what you got. Okay, I filed a claim for PTSD and I got 50%. Okay, that's what I got. Versus actually looking at what are your symptoms, what are the symptoms related to the statute, and whether or not you actually qualify or should have been granted a higher percentage, and advocating for you on that behalf. So the VA has admitted many times when they see a representative, they're going to take a double extra check. They've also told me if they see an attorney that they pay a lot more attention to it, which is laughable to me, but it is what it is. And if I can leverage my, bat, I guess, as a attorney to make sure that the veteran gets what they need, that's worth it. So never do it alone. And the other thing is I always say is to be proactive. Don't just assume that the VA is going to do what they do. Don't sit back if you haven't heard for months and months and not follow up with the VA and find out what's going on. The VA closes cases out accidentally all the time. They fail to send mail that they're supposed to all the time. So be proactive, follow up on your claim, ask the VA what's going on. But if you have a representative, you can do all of that through a representative. We have access to the VA files electronically, so we can see what's going on. You don't necessarily have to call a 1-800 number, call center and have somebody looking at a screen and trying to tell you what's going on with your case. But again, don't do it alone. Be proactive. Those are the biggest pieces of advice I can give. This is Amanda with Veterans Voice. I hope you join us again next Tuesday evening from 7 to 8 o'clock. Or you can always reach us